so nice. Thank you, Dodala. Glad you're back.
I tried to reach you yesterday, and
I
I'm
know.
very frustrated.
I'm sorry.
How do I get through when I can't?
It's not that. It's I got that you was calling, but I was in meetings.
You missed a good movie. And I have 2 more. The talk week is working.
Okay, yeah. So what should I do with this one? Not use it? Because we passed this. This is good. So this is good, everybody. We're kind of like a class, and aren't we the lucky ones? And we have some streaming. Al just asked if we were doing that this morning. He set it up. And I know there are people at home. And I'm welcoming all of us to the COE Watt Wednesday at the Temple. And we set our programs up for the year early and in advance and set them up so that we are presenting classes that we would all like to attend. And we do. And so I am going to introduce, I'm Judy Farber-Weissman, if you hadn't known, and hello. And I'm going to introduce Linda Levine, who's going to introduce our treasured guest today. Thank you very much for coming, Jenna.
So I met Jenna about a year or so ago. Anson and I don't know, we bring in money and then we put it in the bank and we forget it. I mean, I don't know, we're just not interested very much. But my son's friend said, you guys have to get serious. You don't really have a choice. And he told us about some guy. I don't know if you knew that. And then we just couldn't relate. The guy said, okay, well, I'll straighten out your stuff and send me, I don't know, $100, $700, I don't know, money. We didn't know him, and it just wasn't going to happen. We weren't going to react to it. But then Brad Hertz, our friend, called and said, well, you have to meet Jenna because you'll have a whole other attitude about financial planning. And so we just grabbed it. And we went to our meeting. Okay, we went to our meeting with our son and daughter, and we had Michigan daughter on the line. And that felt really good and felt really right to do. We straightened out everything and found Jenna very personable, very easy to talk to, very easy to ask questions of. And that seemed to be kind of what we wanted to be able to do. And then I'm not going to, I think we walked away feeling we had a free year of questions. So that was a nice thing too, because we didn't think of all that we needed to do. So here she is, Jenna Glashock. And her sister's a teacher. She teaches Hebrew here?
My cousin teaches at the Hebrew school, yeah.
Oh, at the Hebrew school. She's a trust and estate attorney. She has her own practice. She grew up in Los Angeles. She went to Echo Horizon Elementary School. I was there yesterday.
Very cool.
And then went on to Harvard Westlake. She went to law school in New York. During her second year, after her mom was diagnosed with advanced cancer, she transferred to UCLA, where she completed her legal school. She spent 4 years as an attorney at Latham & Watkins in Los Angeles, specializing in complex commercial and bankruptcy litigation. She then pursued an MBA, graduating first in her class at UCLA, at the School of Management, where she focused on entrepreneurship. Jenna will talk about anything and everything estate planning related that we want to discuss. She plans to discuss the importance of incapacity planning, the difference between wills and trust, protecting assets for the future generation, and estate implications and upcoming changes to the law. Here she is, Jenna Glashock.
Thank you. All right, is this good microphone-wise? Closer? Would rather not. No, I think they're the same. I will try to stay close to it. If I veer off, let me know. So I'm Jenna. It is nice to meet you guys. I know this doesn't work as well for Zoom, but it would be helpful for me to know from a show of hands how many people have an estate plan that they did at some point. Fantastic. How many people have an estate plan? Yeah. How many people have an estate plan they've updated in the last 10 years? Fantastic. So I am going to kind of do the high level because I think it's helpful even if you have an estate plan, even if you're knowledgeable about this stuff. I take the high level information and I stick it into 3 main buckets that I think are important: incapacity planning, post-death planning, and tax planning. So I plan to go through that, and I also plan to leave a good amount of time for questions because I think that is where this kind of becomes theoretical and starts to feel more practical. But because so many people have done this, thankfully, a little bit, it might be stuff you know, but I will try to make it still useful to everybody. So starting on the incapacity side of things, incapacity meaning being unable to make your own decisions, deal with your own bank accounts, your own healthcare decisions, all of that. And if you have no documents in place and you lose capacity, then from the healthcare side, we're kind of scrambling to figure out what you would have wanted, and at each doctor or each hospital, seeing who they will let speak for you, and it's a bit of a messy situation. On the finance side, that would be an ideal situation because the banks won't do that. The banks won't let anybody into your accounts if you are incapacitated and have no documentation. Even if someone says, I'm her only child and I do everything, they won't let you do it. And so what we do, it is an incredibly important part of an estate plan. Nobody thinks about it, but it's very important, is we put documents in place that allow you to decide now, while you're able, who you would want to take over these duties if at some point in the future you are no longer able. Who do you want paying your bills, dealing with your bank accounts, your home? Who do you want making your medical decisions? What are your preferences for end-of-life care? All of that. And we put all of those wishes into a few documents, and now it is much more seamless if you were to lose capacity to allow your kids, your spouse, your friends, whoever it is, to step in and take over. One thing I always like to note about incapacity documents is that they don't expire. There's nothing on there that says good for 10 years or anything like that. But what we're doing in a real life scenario is somebody is taking this document to the bank or to the hospital or wherever and saying, let me make a decision for this other person. Banks and hospitals and doctors' offices and financial institutions are incredibly risk averse. They are very worried that they will let this other person make your decisions. And really, you're over here totally fine, and they're getting scammed, and someone's going to steal your money, and you're going to sue them. And so they look for ways not to honor these documents. They really love not honoring these documents. And the most common pushback we get against this is they'll say the document is outdated. That is fully made up. There is no law around this. They just make it up. But it's really hard to fight with them, and it's expensive to fight with them. And so we start to see this pushback, in my experience, mostly around 8 to 10 years, when the document's about 8 to 10 years old. And so if you have an estate plan in place, and it's exactly how you want in terms of who does what, but you did it 15 years ago, it might be a good idea to sign new power of attorney, advance directive, those types of documents, even if your wishes didn't change, just to have a new signature date on there to decrease the likelihood of complication if something were to happen to you. Obviously, we'll have questions on that and we can, but that's kind of the high level I always talk about with incapacity planning. The documents, yes. So different attorneys call documents different things, especially in different states, even in California. The finance side is usually in some kind of a document called a durable power of attorney or a general power of attorney or a financial power of attorney. The healthcare documents, we're covering who's in charge, who has access to records, and what your end-of-life preferences are. Sometimes all of that goes in one document called an advance directive or a healthcare directive, something like that. Sometimes stuff is split out into a living will. A living will is typically your end-of-life wishes. Do you want to be kept artificially alive or not? And then a HIPAA authorization, which is who can access your medical records. So the exact names of the documents may vary, but usually it's going to be some kind of a durable power of an attorney, advance directive, and maybe one or two other little things in there. Okay, pausing on the incapacity side, going to the post-death side. There are 3 options for how all of this plays out when someone passes away. Because we live in California, which is called a community property state, which assumes that assets are shared in a marriage, we are usually mostly talking about what happens when a surviving spouse dies or an unmarried individual dies. Sometimes there can be a smaller version of this if a first spouse passes, but in general, let's think about what happens if an unmarried or a surviving spouse passes. In that situation, 3 options for how all of this plays out. Option 1 is the person dies with no will and no trust. The term for that is called dying intestate. That's just the word. And when someone dies intestate, their family has to go to the probate court. The probate court decides who's going to be in charge of the whole process, and the probate court decides who gets everything. The probate court is not just making it up and deciding who they like the best or, anything like that. There are priorities under the law. So the first priority, if it's an unmarried individual, to get everything and to be in charge would be children. If none, then parents, siblings, aunts and uncles, nieces and nephews, out to cousins. So we have this generic order of priority. That is also similar to the order of priority who gets everything. Kids first, grandkids, etc., kind of down to your descendants. If none, parents, if any, then siblings, nieces and nephews, aunts and uncles, out to cousins. So it does stay in the family. I frequently get the call that says, I need to do something so the government doesn't just take all my money when I die. And that's not really what happens. It stays in the family, but potentially or likely not in the way you want. Maybe you have multiple kids and one is clearly a better fit to do this than the other. Or maybe you don't have children but you're sibling and you don't get along and that's not going to be the right fit. And so you have no control over what that looks like. But it does stay in the family. So that's option 1. Option 2 is someone dies with a will but no trust. In that case, again, we are going to the probate court. Again, the court's deciding who's in charge and who gets everything. But now rather than look to kind of the default priorities, the court's going to look to your will and who your will named to have in charge and who your will named to get everything and how they get everything. Rather than just getting a check in the mail for their share, we can be more protective, and I can talk more about that as well. So you get to be much more prescriptive about what this looks like. But it still does go through the probate court process. The third option is somebody dies with a trust. And if done properly, and I'm going to explain what I mean by that because that's very important. If done properly, nobody goes to probate court. The trust says who's in charge. The trust says who gets everything and how it's protected or what that looks like. And so long as nobody fights about it, because of course that happens, is so long as there's no fight, no one has to go to probate court. Probate court is different in every state. So you may have friends or family up in Washington or in New Jersey or a handful of other states who say, oh, why would you ever do a trust? Probate is so easy, because probate is really easy in those states. we are on the opposite end of the spectrum, potentially not surprisingly, in California, where I would argue, a little biased, but I would argue that we have the worst probate system in the country. And there are 3 reasons why our probate system is so terrible. One is that everything filed in probate court is public record, and our filings are very detailed. So there is a public filing that lists out everyone in your family who's getting everything or in charge or in theory would get something, their contact information, a list of all of the assets, the value of all of the assets. And there are people, maybe not surprisingly, unfortunately, who look at every single one of these that gets filed and reaches out and tries to sell your family something or scam them in some way. And so it is a very public process. The second reason we like to avoid probate is it takes a really long time. It takes 1.5 to 2 years on average for a case to go through probate court. As Linda was telling my bio, I moved back to LA when my mom got sick. She passed away when I was in my first year at Latham & Watkins, and I spent 8 years probating her estate. Because we had a few little complications, but not unusual complications. And the process took 8 years. That is unusual. 1.5 to 2 is normal, but 1.5 to 2 years is a pretty long time for closure, for your family to get the money in the way you want, or whoever you want to get the money in the way you want. So there is a delay there. The third reason, and this is the one that typically shocks people the most, it's the most quantifiable, is that probate court is incredibly expensive. There are court costs based on the value of assets, but usually in like the $3,000 to $7,000 range in court costs. The real cost comes in the fact that someone has to be in charge. We call that the administrator or the executor. It is a complicated legal process. So that administrator or executor needs to hire an attorney to help them. In California probate, the administrator, executor, and the attorney are entitled to fees as a percentage of the total assets, not discounted by debt. So the full value of any home, ignoring any mortgage and any other real property, the bank accounts, all the stuff, we add it up, and there is a sliding scale percentage for who gets what. At $1 million of value, which in California, anyone who owns a home, you're automatically gonna be way over that, but I'm gonna keep it low to shock you on purpose. At $1 million of value, the attorney gets $23,000, and the executor administrator also gets $23,000. At $2 million, it's $33,000. At $3 million, it's $43,000. It goes up by $10,000 from there, and then it changes at some point. But it is incredibly expensive. I had a client, we closed out their probate yesterday. He owned his home and some investments, and the fees ended up being $35,000. And it's going to his sister, and it's fine. She also got paid. All of this is fine, but we could have avoided it. It's very, very expensive to go through probate court. Really, when you have real property and you have kind of more detailed wishes about how you want things passed, you want to protect family, the only way to avoid probate court efficiently and effectively is with a trust. And so I always like to point out what the downsides of the trust are so that we're all making our most informed decision. And I would argue that there are 2 downsides to the trust. One is that it's typically a little more expensive for an attorney to do the trust and the stuff that goes with it. We always do wills with a trust and all the incapacity. That whole package is usually, $1,000 to $2,000 more than just a will and incapacity. It's more work, so it's a little more expensive upfront to work with an attorney to do the trust and everything than just a will. The second downside to the trust is I said a trust, if done properly, avoids probate. What that means is that the way the trust avoids probate is we have to retitle everything that you own from your name to you as trustee of your trust. That does not affect how you pay your taxes. It does not protect it from lawsuits. It does not cause, costs or extra complication, but it is a kind of annoying process that you have to go through when you go from owning everything in your name to switching it all over. Real property is typically very easy. The attorney does that for you. Business interests are usually pretty easy. Investment accounts with a financial advisor are usually pretty easy because they're sophisticated and know what they're doing. but it's still, you have to deal with your financial advisor and the bank where you have your checking account and updating beneficiaries on stuff. And it's just an item on your to-do list that's not that fun. Going forward, though, once you have the trust, it's relatively easy because you open a new account. You just tell your advisor you want it to be a trust account. You buy a new house. You tell your agent you want to take it in the name of the trust. That is easy. You don't notice it's in the name of the trust. You're not signing things differently or having to give extra paperwork to everybody every day. It's just that switchover process that's a little annoying. And I want to make sure I'm stressing this because so many of you guys have an estate plan, which is amazing. Even having the trust is half the battle, but the other half is titling. So if you do have a trust in place, let me be your reminder to check your assets, check with your financial advisor, make sure your accounts are titled in the name of the trust or have a valid beneficiary designation. Both those things will avoid probate. Oftentimes we list the trust as a beneficiary or a backup beneficiary. That also avoids probate and lets it go into the trust. So if you've had your trust forever and you feel like I'm good, I did it, kudos to me, that is great. You are most of the way there. But making sure things are titled properly is a very, very important part of this. I don't have a strong preference. If you have a question, please. If it's about what we're talking about now, absolutely. No, I don't think so. I think you have to hit the button. There you go.
I'll believe it. My question is about your comment about the probate court, the downside of the probate court, and the exposure that one has. What exposure does one have if they don't go to probate court? If everything is in a named trust, is there that exposure for a third non-member party to see what assets one has?
No, a trust is a private document. There's no publication of it. There's no anything like that to the public. There are notice requirements when someone passes away. We have to give notice to anyone named in the trust as a beneficiary. We have to give notice to anyone who would have inherited if there were no trust. So if you have a kid and there's a bad relationship and you disinherit them, they still get notice and a copy of this. But it does not get sent publicly to, every bank or published in the paper like a probate does. It is private. Yeah.
I have a question.
Yes.
You said all your assets. So if your bank is already in the trust, if the bank sends you a letter saying they want to update that, why would they do that if it's already in the trust? They want to see that you are still in the trust? Why would they do that?
I could take the entire rest of our time here today complaining about banks.
Okay,
No.
don't.
My point is that I'm not surprised because they're terrible and they try to, it's so bureaucratic. I don't think it's on purpose, but this stuff comes up all the time. So it could just be, it's been in the trust. It's so much of it is they worry they get sued. So it might be that they updated a system and lost some paperwork and want to make sure that if something happens, they have the information. They're just being difficult. Yeah.
If you have a trust that is old, I think we have 2005, and we were told it needed to be updated, and you have to do that through a lawyer, right?
Yes.
So how do you get to know, and the lawyers are expensive, but you also don't know who to trust as a lawyer, so how would you get the information?
Okay, so I think there's a few good questions there. One about the age of the trust, and a trust that's 20 years old. If you do nothing, it'll still work. Trusts also don't expire. It just might not be as effective or efficient as you want. So for example, the laws have changed in certain ways in 20 years. Most notably, about 5 or so years ago, there was a law called the Secure Act passed that changed how retirement accounts are taxed and held. And so your trust might be missing some language here or there that would just make it the most, efficient, most tax efficient, et cetera, most simple, because maybe you've named people who've passed away. That's fine if you have backups, but you can clean it up. But if you do nothing, your wishes as written there, if they haven't changed, will still be followed. There just might be some ambiguity or some tax or cost complications. So I don't want you to think, you know, this stuff doesn't expire, it still works, maybe just not the way you want. In terms of finding an attorney, I do a lot of referring out to other attorneys, a ton of referring out to other attorneys in other states, and confer. I work with a finance firm, I run their estate department, and so I do this a lot for their clients, especially outside of California. And so I can tell you what I look for. I look for an attorney who specializes in trusts and estates. A lot of attorneys who do a lot of contingency work or bankruptcy where they get paid kind of erratically think that estate planning is an easy thing they can add on to their practice to get some kind of more consistent income, and they think it's easier and simpler than it is. So I'm always looking for someone who actually focuses on this area. The other thing is I recommend talk to 2 or 3 people, get a sense of what their process is. Some people like Zoom, some people prefer in person, some people like options, some people want to meet a lot, some people want to meet less frequently. So figure out an attorney who has a process that fits with what you're looking for. And then of course pricing is going to be a little different between attorneys as well. And so that's another thing. The third thing that I think we discount is that these are personal, emotional, intimate conversations, and working with someone who you feel comfortable talking to. And so getting a sense from a consultation of, is this somebody I feel like I can ask my questions to, or somebody who kind of understands where I'm coming from? So I would look that they focus in this area, what their process is, of course their pricing, and then whether it's a personality fit. That's what I look for. And then you can find people on Yelp and Google, but usually a personal referral is a little bit easier. So it's going to, so for a brand new estate plan or a fully updated, kind of starting from scratch update estate plan for a trust, new wills, new incapacity, kind of doing it all, I would assume you're going to find fees in the range of $4,000 to $6,000, $7,000 in that range. You will find people who are cheaper. You will find people way more expensive. But I think the most common type of firm is similar to mine. It's a couple of attorneys, a single attorney, a handful of attorneys. They will probably be in that range. The bigger firms, to the extent you want them, and there's benefits to them as well, are going to be a little bit more. And then there's some solos who might be a little bit less. What? Sorry, she said, how about just for updating the trust? Honestly, I typically recommend you do it all because like those incapacity documents, but the trust usually is going to be at least 50 to 60% of the fee. It is the most work by far, maybe even a little bit more than that. So whatever those percentages break down to, 2 to 3 around there, $1,000 to update the full trust.
My question
Yeah.
is, we have a trust and a will. We amended it, and that amendment was who we wanted to leave specific money, jewelry, art to. I didn't want to go to an attorney and pay for it, so I have been typing it myself, following exactly what the lawyer did 12 years ago, but changing the amounts and the names. It needs to be notarized. Is there anything I should be doing beyond that, or should I just throw it away and start over and go to a lawyer?
So a couple of things. One is that using a separate writing, like a separate document for tangible items is very common. So in my trusts and my wills, it specifically says, go look at my personal property memorandum where I will list out who gets this piece of jewelry, who gets this family heirloom, who gets this piece of art. And I really like that because that is something clients can do whenever they want and shred it and print a new one and never have to pay me anything. So that is very normal for the tangible stuff. I would likely rely on that less for dollar amount gifts. The benefit to having things done kind of perfectly by an attorney is that it makes it less likely that there is a fight about it in the future. And it makes it more likely that if there is a fight, there is someone out there who can attest to your wishes and who's crossed their T's and dotted their I's. Handwritten stuff, DIY, do-it-yourself versions. If nobody there's no trust police out there, right? If nobody fights about it, it's totally fine. And so If you think your family is just going to follow your wishes, then whatever you're doing is likely totally fine. If you think there's going to be a fight about things, I would definitely recommend going to an attorney and doing things perfectly. I will also note, if you are replacing old versions with new versions, please make sure they are either dated or you shred the old ones, because that is a big fight of what was the most recent version of what they wanted. All of that to be said, of course, I'm an attorney. I should say you should always work with an attorney. You know, that's always going to be your best bet, that everything's done perfectly. But again, if nobody's fighting, there's nobody's going to come in and say that, you know, you forgot a comma here and so it's not valid. It's, you know, so long as everyone agrees, everyone agrees.
Jenna, would you like to finish your presentation?
Yes, I'm trying to figure out where I
And then we'll ask
was.
questions afterwards.
You know, I was going to get into more of the tax stuff, so I actually think this is probably a good break for questions on the
Okay.
more basic kind of foundational planning, regardless of net worth side of things.
There's some of us who are just really overwhelmed with the Jewish side of death. And I'm curious to know whether or not that's a conversation that can be actually had with your advisor. One thing that comes up, for an example, is some of us may be inadvertently signed up with the state of California to donate body parts. So the overall question
Yeah.
is, sometimes things get personal, and they're not just documented, written, legal materials. And can you just speak a little bit to that sort of extended relationship and service that one might expect from a relationship with an estate attorney?
I think that directly ties into who you pick, right? Is picking someone you're comfortable asking questions to and having those conversations with. In my documents, we note organ donation preferences, burial, cremation preferences, all that. So we're always talking about that stuff. Absolutely. I will say, one of the things who I was talking to that I love about Judaism is that everyone disagrees about everything. And so everyone, you have 10 people and they have 12 opinions. But I will say I've talked to a Reform, a Conservative, and an Orthodox rabbi about organ donation. The three I happened to speak to all said that they believed that it is allowed under kind of Tikkun Olam and all of that. But those are three people, and I'm sure there's a million out there who agree and a million out there who disagree. But we talk about it, and we can't. I also have a worksheet I include in my binders that people can kind of, in a less formal legal way, write wishes and preferences about end of life, about memorial, about obituaries, all of that. But we do talk about it. I will say I have a pretty good track record of figuring out whether a client is Jewish or not, whether they want to be buried or cremated. There's a very distinct divide there. But we talk about it, but at the end of the day, obviously, it's going to be what a client wants that goes on there, and I'm here for questions. I don't know everything, of course, but we talk about it.
You were saying, okay, everything's fine, you've got trusts, wills, etc., and there's death, and it's private. But everyone named gets notified. Who's notifying?
Oh, so there's three parties to a trust, three people or groups of people. There's the grantor, which is also sometimes called the trustor or the settlor or the trust maker. Of course, we have to have a bunch of names for this. That is the person or the people who create the trust. That will always be those people no matter what happens. Those are the grantors. Separately, you have the trustees. At least we have one term for that. It is always trustee. That's who manages the money, and that is usually the grantor during the grantor's life while they have capacity, and switches to whoever they want if they lose capacity and after they pass away. The third party to a trust is beneficiaries. When we create a trust for ourselves, we are our own beneficiaries. I know a lot of people tend to think, oh, my kids are the beneficiaries. But no, during our lifetimes, we are the beneficiaries. If we lose capacity, we are the beneficiaries. After we pass away, somebody else is the beneficiaries based on what we want. The trustee is who takes over this, or the successor, contingent trustee, whatever you want to call them, is who takes over this process when the grantor or grantors pass away. And that person has a lot of legal duties, one of which is notifying, another of which is figuring out what the assets are, following the terms of the trust, distributing things the way you want, letting the government know, telling the IRS, right? There's this list of things we do. But it's the trustee, the person who takes over after someone dies, who has to do all of that.
Is there a difference between having a certain amount of money given to different people or percentages
Yes.
of what is left?
Very good question. So there are two ways we distribute money out of our trust or out of our estate to other people. Specific gifts, which are dollar amounts or specific items, and what I call residuary gifts, which are percentages of whatever is left. The most important difference here is that specific gifts come out first. And so if you have $10 million and you have 3 grandkids and you want to leave them each $1 million, but your 2 kids each get 3.5, and we say $1 million to each grandkid, my kids split whatever's left, and you end up with $100 million, your grandkids get $1 million each, and your kids get $48.5 million each. If you go the other direction and you pass away with $3 million, your grandkids get everything and your kids get nothing. And so specific gifts come out first, residuary gifts get whatever's left. And that is a very person by person conversation of what you want. Some people, I have a client I talked to the other day, he knows he wants his kids to get $2 million and nothing more. They're babies. He's worried that, they'll have an incentive not to work or whatever it is. And so he knows he wants them to get that $2 million. And if it ends up being less, they'll get that $2 million. But if it ends up being way more, the rest is going elsewhere. And so specific gifts make sense for that. Specific gifts make sense for smaller amounts. Like we don't really need somebody who's going to get $100,000 to get like 0.6% of whatever. But when we get to bigger numbers, we tend to try to use percentages so that it can fluctuate with the size of the estate.
Can the okay, so let's say the first person passes away and there's a trust and there's that amendment to the trust can that be changed by the person remaining? That's number one. My second question, if it's a marriage and one passes away and you don't want that money to go to maybe a third or fourth wife or husband, how do you protect that?
So I think those are a little bit the same question, or at least my explanation I think would hit both. We talk about a lot of wishes when we talk about how to structure this. And one of the big topics, probably the most lengthy time we spent talking about any topic with a married couple specifically, is how assets pass at the first spouse's death. So I'm going to give you guys my normal spiel about this, which is that I envision a trust. This is just how my brain works. I envision a trust like one of those cardboard moving boxes. And when we create the trust, or when we did it 20 years ago, or whenever it was, it's like we metaphorically built out this moving box. And we metaphorically put the tape on the bottom and grabbed a Sharpie and wrote the name of the trust on the side. And when we went through the process of funding, of retitling the assets, it's like we took the assets and dumped them in this box. We picked up your house and we stuck it in this box, and we grabbed stacks of cash from your bank account and put it in this box, and we put everything you own in this box. And during your joint lifetimes, because this is specifically a married couple question, so during your joint lifetimes, you're earning money that gets added to this box, and you're spending money that you're taking out of it, and you're investing different things, and it gets all mixed up inside. And when the first spouse dies, in the background, don't worry reality, but in the background, we're freezing that box. And we're opening up 2 new boxes, and we're writing spouse 1's name on it, we're writing spouse 2's name on it, and we're taking those assets and dividing them into the 2 boxes. Anything that is community property would divide 50-50. If one of the spouses had separate property, either under a prenup or an inheritance, something like that, that would go into that spouse's box of stuff. The box with the the box with the surviving spouse's name on it, we take our Sharpie, we cross off the surviving spouse's name, and we write survivor's trust. So we are always putting half of the community property and the survivor's separate property into the survivor's trust every time. The survivor's trust is very easy to conceptualize because the survivor can do absolutely anything they want with it. They can spend the money however they want. They can invest it however they want. They can remarry and include a new spouse. They can get mad at one of your kids and write them out. They have full control over their share of the money. Nothing we can do about that. That's the law. But we still have this other box of stuff over here that has the deceased spouse's name on it. And for that, we have options. Mainly, I break them down into two options. We have the simple option and we have the protected option. The simple option is we take that box of stuff and we just dump it in the survivor's trust box. And why I said we don't picture in reality is because when we do that, when we say everything goes to the survivor's trust, we never have to split things. We don't have to retitle things. We just leave everything how it is. The survivor continues to manage the money. Survivor continues to spend the money. But the survivor can change where everything goes at the survivor's death. So the survivor can remarry, leave it all to the new spouse, cut out a grandkid who's pissing them off, whatever it is. The more protected but less simple option is we actually create those two shares. So we take the deceased spouse's box over here, and we cross off their name, and we write marital trust or bypass trust. There's a million names for what you would call this. I'm going to call it marital trust for now. We call it the marital trust. And what that means is we actively have to retitle everything. So it's more annoying for the surviving spouse because they have to, with help of course, but retitle their house to the survivor's trust, but then all these accounts to the marital trust and this account 70/30 or whatever you have to do to get the right values. And so there is a process the survivor has to go through, which is a little annoying, but with help from their attorney, their financial advisor, their accountant. The marital trust is there to support the survivor. Survivor typically can get the income from it, can use the principal if needed, but we say try to use it last, use your own stuff first, but it's over here if you need it. You can let the survivor be his or her own trustee, or you can require somebody else's trustee. That's up to you. And it cannot be amended. And so that share is going to go the way you jointly agreed during your joint lifetimes, and the survivor cannot change their mind on that. So the survivor cannot include a new spouse on there, cut out the kids, whatever it is. Sorry. Yeah. So when we have it split to a survivor's and what I'm going to call a marital trust, but it's called a million things, it's there to support the survivor. Survivor can use the income. Survivor can use the principal if needed, but we typically say try to use it last because it's more protected. But the survivor cannot change the terms of where that stuff goes at the survivor's death. So if the survivor were to remarry, let's say, the survivor could say anything left in the survivor's trust, this one over here, goes to my new spouse at my death. But this stuff over here in the marital trust will go the way that the spouses jointly agreed during their joint lifetimes because it cannot be changed by the surviving spouse. So if they jointly agreed that stuff goes equally to our kids in this specific way, that will happen for that share no matter what. So it's more work for the survivor, but more protective of the deceased spouse's wishes. And because none of us knows in a marriage who's going to go first, we all have to agree, which risk do we more want to take? Do we want to take the risk that we're the survivor and we have to do a little bit more paperwork? Or the risk that we are the first spouse and we want to make sure that stuff's protected so nobody else gets it, to figure out what's the right fit? But those are the main options. The simple, survivor can change everything. A little more complicated, but at least part of it is protected.
Could you say the names of those two ways again?
The different names for the trust
simple
over
one,
here?
The simple one where, what happens in this? I'm sorry.
No, that's fine. So the simple option is we just say everything stays in one trust for the survivor, what we call the survivor's trust. And that when it all stays in one trust for the survivor, it's very easy for the survivor because the survivor does not have to go to their banks and retitle things or get a new tax ID or do any added work. Survivor just continues to spend the money and manage the money and invest the money. But now the survivor can go to their attorney and say, I know that when we were both alive, this was what we wanted, but I want to change all of it. And now I want all of it to go to the kid I like more, or the more protective option is that we always have kind of that half, simplistically, that half going to the survivor's trust that the survivor can do whatever they want with, but half stays in an irrevocable trust, one that cannot be changed, which is sometimes called a marital trust, a bypass trust, a credit shelter trust, a B trust. Sometimes we call it the A and the B trust. Lots of terms for it. For now, I'm calling it a marital trust, but irrevocable.
Yeah, we call it the exemption trust.
Exemption trust is another good term for it, yes.
Yeah. So, in the end, everything goes together anyway, doesn't it?
If nobody changes the survivor's trust, then the terms typically stay the
No,
same.
the survivor's trust, I know, can be
Right.
changed. And any interest that's on insurance or anything, that the survivor could take that money out. And if they need it for any really urgent things, they can access that money, right?
Usually, it depends what the trust says. I've seen more restrictive trusts that say they can only use it for, very specific things, or they can never use the principal. I've seen that as well. It depends what the trust says, but most frequently, yes, it's there for the survivor if he or she needs it.
I was gonna have full, if I needed it,
Mm-hmm.
if I need, but my question was, who decides if you need, does a doctor have to decide that you need to that?
No, again, this comes down to the trustee. It's whoever the trustee of that share is decides. The typical terminology we use, kind of the term of art under the law, is health, education, maintenance, and support. We call it HEMS as an acronym. Health, education, maintenance, and support. Yep. Health. The H is health. The E is education. The M is maintenance. And the S is support. It covers, it's so broad. Like that, what doesn't count? I don't know, like a private jet maybe, but it covers so much. And there's so much discretion there. If nothing else, we live in California or in LA where you need a car. There's a Camry, there's a Maserati, there's everything in between. And it's the trustee deciding how that money is spent. Oftentimes, the survivor is allowed to be their own trustee. And then we're kind of relying on the survivor, and whatever it is. Sometimes we require that the survivor has a co-trustee, or we just name somebody else as trustee, and now that person's job is to decide how money is spent for the survivor from that share.
What happens to separate property that you want to protect? Does that go into the marital trust and not get risked of, to the in-laws, as they say?
Yes, so everything goes wherever you say it goes because it's your money. So you can have your trust say whatever you want. And I have clients who just say, I want everything go to the survivor easily, and that's fine. I'd say more frequently where there is significant separate property. Then a very common thing I have is clients will say, you know what, I want all the community property to go to the survivor in the easy way, but I want my separate property to go to that irrevocable marital trust at my death. And that's an option as well. Honestly, it's your money and your family. There's very few things you can't do in here if you want it structured in a certain way.
I remember when we came to your office, I told you I did not want to leave money so that Anson's girlfriend, when I die, can buy a little plane and take flying lessons.
Exactly. I have a colleague of mine who's been a mentor of mine for a long time. He was actually my attorney when I was dealing with my mom's estate. And when he talked to me in the beginning, he calls this floozy insurance. That's his term for it. So I sometimes will call it floozy insurance. Floozy, like for the floozy. Anyways.
Do you always have to have the two trusts?
Nope. You can have one trust. Sometimes we do three, but that's getting into the tax side of things. So the one trust is the simple option. That's where we say everything just stays in one trust for the survivor. 2 is very common. 3 is where we talk about taxes, and I can talk about that if we have time.
Question is, what do you suggest, or how do you manage the follow-up, the support, the distribution, and the advice for children after one passes. So what do you or your firm do in terms of, should one want to sort of have, after a relationship with their estate attorney, feeling more secure, knowing that that pathway following someone's passing has some relationship with the children or inheritors to help execute? What's your standard policy?
This is not what you asked, but you made me think of it, and I think it's important. So I'm going to say it before I forget it, and then I will answer your question. There's only so much we can do legally. There's so much that has to be done from a practical standpoint when someone dies. The most common is figuring out what the bank accounts are and getting access to things. So if you have an estate plan, every few years, I would recommend write out or print out your important passwords, where you keep important stuff, what your bank accounts are, because practically that makes things much easier for people after you pass away. To your actual question, which is how do we make sure there's support? There's the legal side of things, which is that our trusts, and I think this is very common, I think this is actually kind of universally common, allow the trustee to use your money to hire people to help them. So they don't have to go out of pocket to get an attorney to help with the process or talk to the accountant or the financial advisor. So that helps. As attorneys, we have what's called privilege. We cannot share any information about you or your relationship or your documents without permission to do so. And so I cannot, put out an email blast to all of my clients' kids and be like, we did an estate plan for your parents. We should talk about it at some point. That is in violation of I would lose my license. So it is dependent on the client to use that relationship how they want to. We offer family meetings, and Linda mentioned, so I can say this without breaking privilege, like her kids, came and met with us and spoke. I've spoken to them. So we offer family meetings with clients' kids if they want. My advice in general is more transparency in a frictionless world is better than less. So if you have the types of relationships with your family and they have the personalities to support this, telling them a lot of stuff and getting them involved early makes everything smoother in the long run. Obviously, that's not always possible, but where it's possible, I think there's a lot of benefit there. I will also say that, and I think this is also relatively common, my clients take home all their original documents. We send PDFs of everything, and we keep PDFs. So I tell my clients, at the very least, make sure the important people who you've named have, I say my information, but the advice would be your attorney's information, so they know where to go and who to talk to if they need help or have questions. So that's at the very least, make sure someone knows who to talk to. If you're more comfortable than that, I tell clients, send them my information and also tell them where you keep your binder of documents, because sometimes it's not obvious to them as it is to you. So maybe shoot them an email and say, here's Jenna's contact information. By the way, our binder is in the garage on the second shelf or wherever it is. And then if you are extra comfortable, here's Jenna's information, here's where we keep our binder, and here are PDFs of everything, and you can share it. And you can go the next step and say, and also let's schedule a Zoom meeting or an in-person meeting to all sit down so she can explain it to you and what will happen next. So we can all do all of these things. Some attorneys may be more amenable to it or not. I love these things. Yeah, absolutely. It's always going to be on the client, though, to initiate that, because we're just legally not allowed to.
How does power of attorney work? If you have the listed power of attorney, can two people have power of attorney at the same time?
Yes, but there are two risks to that I always flag. One is that two people is 50-50 and there's no tiebreaker. And so if those people fight, it can either be detrimental to the relationship because they can't come to an agreement, or it can be very, very expensive if they end up really fighting and talking to attorneys and getting attorneys involved. So there's a higher risk of complication and cost when we have two people. That can be tempered a little bit by an odd number, but that leads to my second risk of having more than one person, which is, I think we often do it in a very altruistic way to say, then they can share the burden, it'll be easier on them. And while sometimes it works out that way, this goes back to how I could spend all day talking about banks. Inevitably, one of those risk-averse banks is going to say, I know that it says on here in bold, highlighted, each of them can act individually and they both don't have to sign every check and do everything. Inevitably, some bank is going to say, I need you both to come in person at 8 o'clock on a Wednesday to open the account or something like that. So there can sometimes be some logistical snags to it. Of course, the other side is that there is some sharing of the burden, right? There's a lot of stuff that's not formal with a bank, and that stuff gets to be shared with two people. So it's not like I say never, but those are always the two risks I bring up when people ask.
The binder, two things before the binder, one thing. I involved both of my daughters in this process. They were right there with me, and because everything would go directly to them and then dispersed. And, but one daughter is, with the agreement of the other, in charge. The binder. The attorney put together a binder, and it was her suggestion, and it had in it, has in it everything that you've discussed, even the deed to the house. And her suggestion was that at every birthday of mine, that I go through and update all of my bank accounts, the last most current bank account statement, anything that can be updated to be updated, passwords, and I'm not sure that I have those in there, and that's wonderful that you said that. But that I walked out with that, notebook was an excellent, that I could open up and use and replace, was so helpful, and I'm thrilled to hear that that's what you do as well.
This may be when you're going to talk about taxes, but do trusts need a tax ID number?
That is a very good question. Everything I've talked about so far, I've said the word trust. What I've meant is revocable living trust. That revocable living trust is our kind of corollary to a will. It's our foundation of a estate plan. It's who gets what, when, and how. A revocable living trust uses our own social security numbers as its tax ID. It does not need a new tax ID. When a trust becomes irrevocable, like when someone passes away, that's when we get a new tax ID for it. But so long as it stays revocable, any part that stays amendable or revocable does not need a new tax ID.
So on death, the trustee has to apply for one.
Exactly.
Okay, and so if there's separate property, is there any reason to get a tax ID for that before death?
No. No. I mean, having extra tax ID is just kind of a pain. Separate tax returns and having to, even if it's zeroed out, kind of annoying. Where there is, and I didn't mention this earlier, where there is significant separate property that we want to treat very differently from everything else, we will often do a joint revocable trust and a separate property revocable trust. I will say I have this for myself. I inherited some money. My husband and I have been together 20 plus years. It's all I trust him, all of that. But to me, it was much cleaner in my head, and also I can do it for free because I do this for a living, but it was much cleaner in my head to see these accounts are listed in the Mark and Jenna Glassick Trust. These accounts are listed in the Jenna Glassick Separate Property Trust, and it just helped me clarify. You could put language around all of it in one trust, but you can have multiple revocable trusts as well, and that comes up a lot with prenups, honestly, where we're creating some community but keeping a lot of separate. I have clients will do 3 trusts, a joint for the joint stuff, usually the home, separate for the spouse 1 separate stuff, separate for spouse 2 separate stuff. The only downside to that is whatever you have to pay an attorney to draft another trust.
Question. I have always told my children not to commingle inheritance. Is there something I should do ahead of time in the will or in the amendment that says it in writing versus just telling them? I'm concerned if I have a single child, what if she gets married? What if someone tries to take money, etc.?
Yes, this is very similar to the question that I answered about what happens at the first spouse's death. This is the topic we talk about what happens when the survivor dies. So I will go through that spiel quickly as well. And so let's assume kind of the not exclusively but most common situation. It goes to a survivor and then goes to kids. It can go to kids in kind of the same two ways, simple versus protected, that we talked about with the deceased spouse. Simple is we say, money goes to my kids in equal shares outright at my death. Or with younger kids, or if we have stuff going down to grandkids, they get a third at 25 and a third at 30 and a third at 35. That's not very normal language we see. And that is what I'll call my simple option, because it's very easy. They get it, it's in their name, they can do whatever they want with it. It's just it feels easier to people. But it is totally unprotected. If they get sued, if they cause a car accident and they get sued, that money can be attached to a lawsuit. If they get divorced, if they're really good about not commingling, they might protect a bunch of it, but no one's perfect. And so usually some chunk ends up going to a future ex-spouse. If they pass away without their own detailed estate plan, a big chunk can go to a spouse rather than stay in the bloodline. It could go through probate. So it's totally unprotected, but it's a little easier for them. I do have a strong opinion in that I really actually like the more protected option here, which is that rather than say it goes outright to them or they get it all at 30 or whatever you might say, we say it goes into trust for them and they get to be their own trustee. And all of that means in real life is that survivor dies, we do some administrative stuff, and then once we're ready to distribute to the kids, your trustee gets a new tax ID for your trust for the benefit of kid 1, a separate tax ID for your trust for the benefit of kid 2, however many kids there are. And let's say we open up an account under that tax ID, and rather than write a check to the kid, we put that money in this account under that tax ID. And if we are gonna let the kid be their own trustee, then now it won't feel that different to them as if it was outright, because they can spend it and they can decide how it's invested and they can mess all this up and take it out if they want. But humans are inherently a little lazy and it's there for them and it's easy and they have control, so they leave it there. And now, if they get sued, it's more protected. It's clearly segregated, kind of what we're saying about a separate property trust. It has a different name. We know that that is inheritance, that is separate property. It will stay out of probate at their death. It'll stay in the bloodline or however you said you wanted it to go. And so, again, they can mess it up, but it nudges them. It gives them at least the option of having all these really great protections. For a kid who we don't trust to manage their own money, we would put it in this type of trust, but just not let them be their own trustee. We would name someone else in charge of their money for them. But if we have a financially responsible adult children, I still say, let's put it in trust for them. Let them be their own trustee. Hope they don't mess it up. And, then it's much more protected for them.
So if you have all these different trusts, protected money, so to speak, you still have to go through the process of figuring out what to do with them in case you die, right? Because you have all these, how would they otherwise know where this money went, this protected money?
So
you have to go through the same process with each trust, right?
So to be clear, when I say I want money to go to kids in trust rather than outright, I am not suggesting we draft a trust for you and a trust for this kid and a trust for this kid and a trust for this kid. All the language that we need is going to your trust. We still just have that one revocable trust for you. And what that trust says is, at my death, when you're ready to distribute money to my kids or whoever it's going to, put that money in trust for them under these terms. We put all the language in your trust. And so the only added work it really is that the trustee gets a new tax ID when the survivor dies. We don't need to draft like a whole new trust document for everyone. It's really whatever section of your trust says my stuff goes to my kids outright when I die. It's just a slightly longer section that says my stuff goes to my kids in trust when I die, and here's the rules. Yeah.
Jenna, you've been a yeoman here. We're going to have one last question,
Sure.
okay?
I could do the tax part quickly when we're done with it. Okay. Okay.
Okay, thank you. I just want to emphasize a point that you made that was basically exquisite. For those of us that have adult children and we're leaving lots of different things to them, what I had heard on the street was maybe your child isn't responsible enough and you'll want to have this separate trust, controlled and by someone else or regulated or with oversight. The point that you made is so impressive to the idea that you have adult children and they are very smart and they can take care of things themselves, but the idea of protecting the assets for them is a gift. And I have not heard the rationale for that for your adult children, and I just want to emphasize the value of the gift that I can be giving my son to have that in place, not because he's not good enough, but because it's a very smart, loving thing to do for him. So thank you.
I will say, oftentimes, like with Linda, I have the adult children in meetings, and so I just turn to them. I'm like, I don't think your parents care. What do you want, right? This is about you. 95% of the time, they ask for it in trust. So really, this is, I think, not in any way trying to hinder them. It's just protecting them. All right, do we have a couple minutes for quick taxes?
Whatever you want.
Okay. Okay. So there's a bunch of different tax structures that affect all of this. One is property taxes, because I know in LA we really, really care about that. And the law has changed in a bad way as to how that works. Your property tax basis, how much you pay property taxes on, is set when you buy your house. And it increases every year as the value of your house increases, but it cannot increase more than 2% a year. And we are in LA, and our houses have increased in value more than 2% a year. So usually, the property tax basis, the value that is used for calculating your property taxes, is very different than the actual value of your house. I had a client yesterday. His mom bought her house for $20,000. It's currently worth about $3 million. So she's not paying taxes on $20,000. It's gone up a little bit every year, but she's probably paying taxes on $100,000, $200,000, and it's obviously worth 10x that right now. When we transfer ownership from one person to another, we reset that property tax basis to the value at the date of transfer. It used to be that we could give our home to our kids and it would not reset. That has changed. Now, it has to be your primary residence. A child of yours has to make it that person, his or her primary residence. And even so, they only get protection of $1 million of gain. So my example where I went up $3 million, the taxes will reset to essentially a $2 million value rather than $3, because we get $1 million of protection against the gain, but it will still go up significantly. Any property that goes to anyone other than your kid, any property that is not your primary residence, or even a primary residence that goes to a kid who doesn't make it his or her primary residence, will fully reset. This law was really pushed by the real estate lobby, who wanted more sales. And so there is, in theory, sort of a way around it, but it's incredibly complicated, and the assessor is cracking down on it. And I'm in the middle of it with a couple clients where the assessor is starting to reassess. And so, in general, it just is what it is. If you're mad about it, tell your congressman. Let's try to get it changed. So that's the property tax side, and there's very little we can do about that right now. There's income taxes. That is, yes, it's money that's paid on when you earn money, but what matters here is money paid or taxes due when you sell an asset. When every asset we own, our house, stock, anything, it's also called a basis, which is really dumb. It's a different basis, but let's call it a basis. And that is essentially simplistically what you bought it for. So using stock as an example, you buy a piece of stock for $1. You sell it for $100. You owe capital gains on that difference, which in California, between state and federal, is about 1/3 of the difference. So you sell it for $100, you pay $33 in taxes, you keep the rest. The law says, right now, it could change. The law says that if you don't sell it for $100, but you own it at your death at a time when it's worth $100, the basis steps up to date of death value. And so now if your kid sells it the next day for $100, they pay no taxes whatsoever. So the basis, the capital gains basis, which is usually what you bought something for, that will reset to date of death value for anything you own. So you could sell it with no capital gains, not you, because you're deceased in this example, but your kids could sell it and pay no taxes. So that $33 you would have had to pay the day before, your kids now pay zero. Obviously, we don't care about $33, but we imagine a house that we bought for $20,000 that we sell for $3 million, right? That's $1 million in taxes that you would pay if you sell during your life. Your kid sells it for $3 million the day after you pass, they pay no taxes. They sell it a year later for $4 million, they're paying tax on that $1 million of gain, but not the full $4 million. So capital gain step up is incredibly valuable under the law. So that's one thing, and we don't have to do anything about that. That just is what it is. Yes? I want to make one point as she's bringing the thing. California is what's called a community property state. The one tax thing that works out really, really well for us in California is in California, community property is treated as if both spouses each owned 100% of that, which is not a real thing because that is 200%, but that's what the law says. If you are a surviving spouse, every single thing you own jointly with your spouse got a full step up in basis as of date of death. And then it will get another full step up in basis when the survivor dies. So that is a great tax thing. Yes, Judy.
You're saying that if our children sell the house right immediately after death, they get a step up and they don't have to pay.
Capital
They get
gains.
a zero. They don't have to pay capital gains.
Yes.
But if they wait, and one lives in it, and one,
Then-
oh,
But if they wait and
that's why I don't sell.
if they live in it, then their property taxes are going
If they
up,
live
right?
in it. If one lives in it but the other buys that half out, then that's a big problem for taxes.
No, not necessarily. I mean, there's two different taxes, right? From a capital gains tax perspective, no, they still got that $3 million basis. If they sell it in the future, yes, they'll owe some taxes, but only back to $3 million, not all the way back to the beginning. So they get that new basis no matter when they sell, and that's great. The problem if they don't sell it is that probably the property taxes will go up. And so the annual tax might be a little higher. But that capital gains benefit they get whether they sell it immediately or later. We build that in as of date of death.
Okay.
Hi. You haven't discussed this exactly yet, but in a situation with a second home, in a situation with a second home, I've been waffling. As somebody said, the word on the street is, and I know people that put it in their second home in their children's names before they die, and that's a whole situation. I have just, I guess, for sort of psychological reasons, been not wanting to do that. I like the idea that it's still, kind of in our ownership. But I trust my kids totally. And I also thought that maybe it's a little complicated in terms of the parents still. You can't put on your kids to pay all the maintenance of the second home. So it seems more complicated financially for the maintenance. So do you have an opinion about whether it's a good idea to do this or not do it, to give it to them ahead of time?
Do not, in most situations, but not all, do not put your kids on the deed to any real property. They will lose that step up in basis. And the property taxes probably will also reset now. And so if you're buying a new home, sometimes we'll put it in their name so that we don't get the property tax reassessment if they plan on keeping it like forever, because then at least we'll get the step up at their death. But if there's a chance they might sell it, or if you've owned it for a long time and it's had a gain in value, do not give it to your kids right now, with some caveats that I'll talk about in a second with estate taxes. Do not give it to your kids right now. They will lose that step up in basis, and it's very valuable.
Okay, because we've owned this home for 30 years
Oh, no,
now,
no,
and
don't
it's
do it.
got a huge.
Don't do it. Yeah.
You know,
Yeah. And there's a question in the back as well.
Yes. Two things confuse me. Two things confuse me. One thing is the irrevocable part of the trust, which theoretically I can use if I really, really need it and I've spent all of my other. But if I don't use it, what happens to that?
It goes in the way your trust says. So whatever you guys jointly agreed.
It comes together with the other and goes out.
Yeah, simplistically.
The other thing is, many years ago, we had an attorney who specialized in real estate, and he had us put our kids on the deed so that a percentage of the house belonged to them. That's where it is. Should I rewrite that deed?
So it goes into my estate tax talk, which I will do in a second. There are competing tax interests, and the estate tax laws looked very different 10, 15, 20 years ago. And so it might have made perfect sense at the time, and it might no longer
It was
make.
good at the time.
Right.
It's lousy now.
So, yes, in theory, you could take them off. There are tax implications to that, so you'd want to talk to your accountant about it as well, and making sure that taking them off is not considered a gift from them to you that has gift tax implications. So there's not a simple answer. Also, the laws may change again. Who knows? I don't have a crystal ball. But I think it's probably worth at least talking to your accountant about what that might look like, and your attorney as well. All right, one question in the back, and then I want to talk about estate taxes as well, in the vest. No, it's okay. In the back.
I think this has been very interesting, and I think that each person has a very individual situation, and so it's difficult to ask a specific question. I do know that many of my friends are keeping their homes, moving into a smaller, either a condominium or assisted living or one of those types of arrangements. And they're doing this so they do not have to, they don't want to sell their home.
Right.
They don't want to pay, you know, I've been in my home almost 50 years, so there's been a considerable appreciation. And so, though you want to use the money, I think it's probably a smart thing for these people. Then they rent out the house, and that's why there are so many rentals and et cetera. So,
Yeah.
if I'm wondering if my trust, our trust, was done about 10 years ago, approximately 10 years ago. And it's a very simple arrangement. I'm still married for 60 years. My husband at this time, I'm alive, he's alive. We have only one surviving child. So it's you know, I've been listening to all of this. I have to go back and look at what we wrote. We wrote this after my son was murdered, so that, you know, that was built into this new document. And I'm wondering if we have to change it in any way. At this point, 10 years doesn't seem like a long time, and yet the laws have changed.
Right.
And I'm just wondering, wondering if we need to update it or.
I would say it's a good time to review it, and you might not need to update it. There have been changes in the law, but none that I think is. I'm not going back to my clients from 10 years ago and saying we have to make all these changes because of the way the law changed. I don't think there have been any kind of tectonic shifts in the law that would affect it in that way. but always a good time to look at it because your assets have changed, and your wishes may have changed, and your child's life may have changed. There might be grandchildren or a spouse or whatever it is. So I think a good time to look at it, and you may choose to leave it exactly how it is, or you may choose to update it.
I had a question about, and I missed part of the discussion. I loved your term, the floozy,
Yeah.
clause.
Yeah.
Yeah. Could you just explain that again? In other words, if you don't want certain of the assets
Yes.
to go to
The new person.
a
The
new
floozy. Yes.
yeah, I mean, my mother died when I was 16. I understand what happens
Right.
and what happens to men specifically. Yeah, I think you are.
So what we do in that situation when we want that protection is we just say at the first spouse's death, the assets split into 2 shares, a survivor share and what I am calling for this purpose, a marital trust share, credit shelter share, whatever you
Okay.
want to call it. And that separate second share we create, that cannot be amended to include new people. And so
I
that's
see.
how we get that protection.
I see. Thank you so much.
Of course. Really quickly on estate taxes, because I think it's an important part of this. So there is no estate tax in California. It's another great tax thing we have, so we don't have to worry about anything at the state level. But there is a federal estate tax that is levied when somebody passes away owning assets. Right now, and for a long time, that estate tax rate has been 40%, 40, but only above a certain exemption amount. You can give out a certain amount tax-free. Anything above that is taxed at the estate tax rate. That exemption amount has changed drastically over the years. And this probably gets into kind of the stuff we were talking about as well. It started very, very low. In 2010, it was set at $5 million per person, $10 million per married couple, adjusted annually for inflation. And for 7 years, it went up that way. In 2017, the Tax Cuts and Jobs Act doubled those numbers, and it went up to around 11 something per person, 22 million per married couple. And for the past 7 years, it has continued to go up from there. For the next 2 weeks, it is 13.61 million per person, 27.22 million per married couple. In a few weeks, it will become 13.99 million per person, 27.98 million per married couple. At the end of next year, the Tax Cuts and Jobs Act expires. And if allowed to do so, everything will just cut back in half to around 7.5 million per person, 15 million per married couple. But the longer name of the Tax Cuts and Jobs Act is the Trump Tax Cuts and Jobs Act, and he has already promised to try. Sorry, I was trying to get through it. The longer version of Tax Cuts and Jobs Act is the Trump Tax Cuts and Jobs Act, and he has already promised to extend it, and he has control of both houses of Congress, so we are assuming it will be renewed. And so that means even in 2026, it will stay high. It will go to around 29, 30 million per married couple, 14, 15 million per person, and it will continue to go up from there. If your assets are less than that number, then we don't worry about estate taxes right now. If they are more than that number, then we do, and I could do a whole nother 2 hours about that, so we're not gonna do it, but talk to an attorney, and there are options for how to try to lessen the impact or lessen the risk of those taxes. That was the quick version.
Thank you very much, Jenna. It was wonderful. I'm sure we have other, you'll be stopped and asked other questions.
As long as I'm out by 12, I'm fine. Yes. I will say thank you guys. I never use my cards for anything, but I did bring them today, which is very exciting. Harvard Westlake, 2003. Which Joanna? Of course, I will put these out as well.
I feel like I'm talking to the converted,
All I do.
but. Oh, wait a minute.
Always switch, but as new attorneys cannot do like a short little amendment to an existing document. We have to
Do you have to use the attorney you started with?
No, no, they're just sometimes a little cheaper because they have your file already, but you have your documents to go.
The people we used were
I just did a portability return
There you
because
go, 706.
I did a 706. It was expensive,
Get it,
but
but it's valuable.
yes, because I didn't know, and the differential between my husband, whose deceased estate, and mine, which I don't know.
Yeah, you don't know. And now you have 13 point whatever less to worry
I thought
about.
it was 12.6, but
It might have been whatever year. What year was it?
this year.
13.6. Unless he gave gifts during his lifetime, that might have lowered it.
Well, it was as of 22.
Oh, so it was 11.
It was, I think it was 12.6.
It might have been something.
But
in that
anyway,
range. Yeah.
I was given that.
Yeah.
Thank you. Thank you.
Of course. I'm so glad. I'm so glad. Educating about this is important to me.
Thinking about this,
No,
you know,
it's not fun.
because of the planning, but. Yeah, and it was a ridiculous amount of money.
Yeah, exactly. So it's me. I brought on a partner a few years ago. She's in Orange County, and then we have. Oh, amazing. Where in Studio City are you? Oh yeah, absolutely, yeah. I'm right by Beaman Park, by the library. I'm on South Street, the library. Are you really?
Please take some lemons from Dodie's tree. Lemons, they're big, they're giant. She wants to share her lemons. Do take it home. On the table, sorry.
All right, I'm going to. Yes.
I don't think you asked me, and I didn't tell you, but we paid $300 to you.
Oh.
So I have your card, and I'll send it to you.
Thank you. This was so lovely.
What'd you think?
I think it was great. The questions were so insightful and detailed, which I love. I love talking about this stuff. It was really lovely.
And maybe you'll get some more from it.
Yeah, absolutely. I mean, that's always a nice thing. Even if it doesn't happen, I like doing these types of things anyway. It's nice to educate and be a resource.
No, you'll be on their thoughts. You were wonderful.
I'm so glad.
If they want you back, would you come?
Anytime, of course.
Okay.
Yeah, absolutely. And I can leave some cards out as well. I have a 12:30 meeting, so
Take
before I
some
get over the
food.
hill, I will definitely grab some cookies, as you said earlier.
Thank you very much.
Of course.
Okay, so, yeah, so the electron on the side?
Lectern